Welcome to this explainer. Today, we're taking some seemingly complex constitutional laws and turning them into a crystal clear map of your everyday freedoms. We're going to be diving into a fascinating set of handwritten notes detailing Part 3 of the Constitution. Specifically, we're looking at Articles 20 through 24. And these really aren't just dry legal codes. They're literally the blueprint of our personal liberty. Let's get right into it. So here's our agenda for today. We'll be covering 4 core pillars: protections for the accused, the vast right to life, navigating arrest and detention, and finally, defending against exploitation. All right, starting things off with Section 1, protections for the accused, which falls under Article 20. So Article 20 is basically our ultimate safeguard when the state accuses someone of an offense. It gives us this first absolutely massive protection against arbitrary state power by prohibiting what are called ex post facto criminal laws. Simply put, criminal laws can only have a prospective effect, meaning you absolutely cannot be convicted for an action that wasn't legally defined as a crime at the exact moment you committed it. Nor can the state just suddenly decide to increase the penalty after the fact, punish you more harshly. Basically, the rules of the game can never be changed retroactively just to trap you. Next up, we have protection against a concept you've probably heard of: double jeopardy. This means punishing an individual twice for the exact same crime. The Constitution strictly prohibits this practice, so if a crime is committed, no person can be prosecuted and punished for that same offense more than once by the state. It's a crucial rule, ensuring that once you face justice, you're free from the nightmare of endless repetitive legal harassment for the exact same incident. And rounding out this foundational trio of rights is the protection against self-incrimination. The state absolutely cannot compel an individual to give self-incriminating evidence. In other words, if you're accused of an offense, there is no way you can be forced to be a witness against yourself. This is an incredibly important real-world shield, guys. It's exactly why forced confessions or any form of physical coercion and intimidation during police interrogations are strictly unconstitutional. The burden of proof lies entirely with the states, not on you to somehow prove your own guilt. Moving right along to Section 2, the vast right to life, covered by Article 21. Now let's explore how those previous protections build into Article 21, which is arguably the most vital, living piece of the entire Constitution. It simply states that no one can be deprived of their right to life and personal liberty. But there's a really fascinating legal evolution here. See, the original constitutional text relied on procedure established by law, which is a concept of Japanese origin. Under this, courts essentially just ran down a checklist to see if a law was enacted by a competent authority and followed the right procedure. But the landmark Maneka Gandhi case changed the whole shebang by introducing the U.S. concept of due process of law. Now, the court doesn't just check the procedural boxes. Due process acts as this profound moral filter, ensuring the law itself isn't tyrannical. The law must be just, fair, and reasonable, incorporating the principles of natural justice, meaning authorities must act in a completely unbiased manner. Now, because of that incredibly broad interpretation, Article 21 might seem a bit colorless or vague at first glance, but liberal interpretations by the judiciary have evolved it into this massive umbrella of inferred rights. The courts have decisively ruled that a mere animal existence just isn't enough. The right to life includes the right to a dignified life, livelihood, privacy, and a speedy trial. It even expands to guarantee a clean environment, timely medical aid, and, get this, surprisingly relatable everyday necessities like the fundamental right to sleep at night in peace. And, this evolution is still happening today. In a totally fascinating recent ruling from April 2025, the Supreme Court declared that inclusive and meaningful digital access to e-governance is also a fundamental part of Article 21. This actively forces the state to build inclusive digital ecosystems for marginalized, vulnerable, and disabled sections of society, even directing the government to make KYC processes more accessible. It's just a perfect demonstration that the Constitution truly is a living document, actively adapting to the digital age to keep us protected. Tucked right beneath that massive umbrella, we definitely can't forget Article 21A. Added by the 86th Amendment Act back in 2002, this vital provision guarantees free and compulsory education to all children from 6 to 14 years of age. Education was deliberately added here because, it's the necessary foundational building block. Without education, it's pretty much impossible for an individual to truly understand, advocate for, and exercise all the other fundamental liberties we're talking about today. All right, that brings us to Section 3, navigating arrest and detention under Article 22. Stepping a bit deeper into the legal framework, we really need to examine the specific procedural rights granted when an individual's liberty is directly challenged by state authorities. To truly grasp your rights here, we have to differentiate between two drastically different types of detention. First, there's your standard punitive detention. This happens after a crime is committed, an investigation is wrapped up, and a trial has taken place. The second is preventative detention, and this one is entirely pre-crime. It's when someone is detained purely on the suspicion that they might act against the state in the future, using laws like the National Security Act or the UAPA. In fact, our source notes explicitly highlight the UAPA as the most misused law, which really underscores the serious gravity and potential for overreach when the state detains citizens based on suspicion alone. So let's look at your standard procedural rights under a normal punitive arrest. You must be informed of the grounds of your arrest, you have the right to be defended by a lawyer of your choice, and crucially, you must be produced before the nearest magistrate within exactly 24 hours. This strictly limits police custody. And here's an important detail. That 24-hour window actually excludes the journey time taken from the place of arrest to the magistrate. This exclusion is really just a practical, logistical necessity to account for remote arrests, rather than some loophole for authorities to exploit. But the real kicker is how drastically this timeline shifts under preventative detention laws. Under these specific security laws, a person can be detained based on suspicion, but they cannot be held beyond 3 months. If the authorities want to extend the detention past that 3-month mark, it absolutely requires the formal recommendation of an advisory board. And why is this specific board so important? Well, because it must consist of individuals qualified to be high court judges. This strict requirement ensures there's a high-level, independent judicial check against any potential state paranoia or overreach. Which leads us to our final section, Section 4, Defending Against Exploitation, covering Articles 23 and 24. So for this last part of our explainer today, we're looking at how the Constitution acts as an impenetrable shield for the most vulnerable members of society against forced exploitation. Article 23, Clause 1 completely prohibits human trafficking and a practice known as begar. Now, begar is forced labor, where a person is compelled to work either with or without wages. By prohibiting this, the Constitution effectively outlaws slavery, servitude, and the compulsion of vulnerable individuals, with a huge emphasis on protecting women, children, and the disabled from performing immoral acts. It carries immense moral weight. However, there is a super fascinating, almost curious exception mapped out under Article 23, Clause 2. The state is actually legally allowed to compel citizens to render public service. A classic, everyday example from the source material is when the government compels public officials to perform mandatory election duties. It's a really interesting constitutional caveat where, in highly specific public interest contexts, the needs of the state can temporarily override individual choice. Transitioning over to Article 24, the law explicitly prohibits the employment of children below 14 years of age in factories, mines, or any hazardous occupations. And this safeguard was heavily fortified and modernized by the Child Labor Amendment Act of 2016. That amendment took protections a massive step forward by banning child engagement in all occupations across the board, while specifically regulating how adolescents can be engaged in non-hazardous processes. And the state definitely backs these moral protections with some severe, tangible teeth. Violating these child labor laws is absolutely not taken lightly. The punishment results in mandatory imprisonment, ranging from a minimum of 6 months all the way up to a maximum of 2 years, alongside heavy financial fines ranging from 20,000 to 50,000 rupees. And in some cases, violators are hit with both. Now, it's a powerful system of rights, but enforcing it requires immense responsibility. Returning briefly to the gravity of detention we talked about earlier, the Supreme Court has frequently taken up petitions regarding the misuse of power. They've noted that while authorities definitely must remain vigilant to protect society, any indifferent attitude or execution of power defeats the very purpose of justice. Preventive detention is a serious invasion of personal liberty, and the constitutional safeguards protecting citizens remain absolutely 100% non-negotiable. As we wrap up this explainer, I really want you to consider the delicate balance we've just mapped out today. It's this constant push and pull between the sweeping, protective powers designed to keep society safe and the fragility of our individual, hard-won fundamental rights. When state security directly clashes with personal freedom, how much liberty are we truly willing to sacrifice to feel safe? It is the central question of our Constitution, and honestly, one we must constantly ask ourselves. Thanks so much for learning with us today.